Thank you, Rita, and thank you, Johannes and Kasani, for this very insightful presentation. So my presentation today is titled Doing Business with Your Competitor. And what I plan to discuss right now is actually this dual distribution scenario that both Johannes and Kasani also touched upon a little bit. So I will just try to do it a little bit more illustrative, so you will get the idea on how this in practice will work for you. So dual distribution, basically, it's where a producer or supplier sells through its distributors, but also sells directly to end customers. So you can see this illustration here. On the consumer level, basically, the producer is also competing with its own distributor, right? So at the moment, we have this vertical block exemption regulation, and that has been already in place for a lot of years now. And in these rules that are already in place or used to be in place, usually vertical agreements between competitors are excluded. But this dual distribution, as explained, is covered. But what now changes is basically three things. So first, this exception of dual distribution also covers wholesalers and importers. So on this illustration, you can see that the exemption when a potential agreement is allowed according to VBRR is also a possibility where it's not a producer, but a wholesaler or importer. And also, as Johannes also mentioned, there are changes in rules of information exchange and hybrid platforms. So I will touch upon these main changes in a little bit more detail. So first, with regard to information exchange in dual distribution. So basically, the rule is that information exchange is possible, but it is possible within some boundaries. And now we have guidelines that are quite extensive, and these guidelines give some boundaries on this information exchange. So the basic premise is that it is allowed to exchange information in this dual distribution scenario that is directly related to the agreement, and that is necessary to improve the production or distribution. Now, this is the wording, but of course, this kind of raises quite a lot of questions, right? Is this necessary? Quite a heavy burden of proof? Does it mean that the information has to be indispensable in a way that absent the information, the efficiencies would not realize? Or is it enough that the information is useful and relevant for the distribution and distribution chain? So to kind of clear this up, the guidelines actually have a white list and a black list of information. The white list of information is such kind of information that would be usually allowed. So this is non-exclusive, non-exhaustive. So this means that this is not the only information that can be exchanged, but it is an example list that usually would be allowed. And so I have just listed here the information that usually should be allowed, but of course it is up to individual assessment as well. So first we have technical information relating to the goods or services, also logistical information, inventory, stocks, also sales prices from the supplier to the buyer, also suppliers recommended or maximum resale prices, and information on resale prices, but you should pay attention that this resale price information should not be aimed to enforce a fixed or minimum resale price. So also what is usually allowed information is customer purchases, customer preferences, customer feedback, also marketing of the contract goods or services. And also performance-related information. So, for example, aggregated information on marketing, sales activities of other buyers, and also the volume of buyer sales relative to the sales of competing goods or services. So in contrast to this white list, we also have the blacklist. So this is the information that usually is not allowed. For example, future prices downstream, also identified end users, unless this is somehow necessary, for example, to satisfy a particular end user or something like that. And also blacklisted is any information relating to goods sold by the buyer under its own brand name and exchanged between the buyer and the manufacturer of competing branded goods. What I would like to also emphasize is that the information exchanged in this distribution scenario also can depend on which type of distribution setup you have. So, for example, exclusive distribution, franchise agreements, selective distributions, all of these kind of have different setups, and it is necessary to exchange different kind of information in these scenarios. So this can also be taken into account. So just to illustrate, I have put on a slide quite a recent case from Denmark Competition Council, where there was information exchange on prices. And maybe the takeaway from here is that why we don't allow such kind of information exchange, that this actually gave the possibility to coordinate the retailers' future sales, and may have led to more uniform range of products and lower discounts and so on. So this is with regard to information exchange. Now, with regard to hybrid platforms, we have another kind of change. So when usually in dual distribution scenarios, the competing parties use different distribution channels. So this means that producer has its own, for example, retail shop, and the distributors have their own retail shops. Now, in case of hybrid platforms, the same channel is used by both the supplier and its competing sellers. So this means that more competitive problems might arise on this level. And this is why, with regard to hybrid platforms, the exemption actually does not apply. So, for example, just to illustrate this, we can bring the example of Amazon, where we have ongoing proceedings. And Amazon, for example, has this kind of a dual role. And the European Commission has stated in their press release that the data on the activity of third-party sellers should not be used to benefit Amazon when it acts as a competitor to these sellers. So this is where the problem of hybrid platforms actually arise, and why the changes in the regulation were basically necessary, perhaps. And now, just to kind of sum up and give you the practical takeaway, is what to do then. What should every company then kind of take out of this? So for online platforms, yes, in some cases the exception does not apply, but it is possible that the online platform can get an individual exemption, which needs an individual assessment. And also it is possible to get kind of de minimis exemption when the market shares are quite low. So just for hybrid platforms, this is not the end of the road for you, definitely. And there are different solutions on how to provide comfort that every competition law rule has been followed. But maybe what is more important is the takeaway for these kind of suppliers who also have their own retail outlet. So these I have listed here now, a takeaway to kind of keep in mind. So first, keep information exchange to what is necessary and directly related to your distributor sales contract. So this means that if you as a supplier also have your own retail outlet, then do not provide information to your distributors, the retailers, about your own retail activities. For example, about your future price changes in these retail outlets, or retail price components in these retail outlets, or promotion timings, or future marketing strategies, or participation in a planned tenders, or other retail sales results. And so this also would mean that do not agitate to increase prices at the retail level and avoid referring to retail price level when negotiating sales prices. So this basically means that you should keep it separate, the distributor sales contract and your retail outlet. So just 3 also precautions that could be taken in the view of this information exchange regulation is: first, if you know that some data needs to be exchanged, then it's possible to aggregate this data so that individualized company level information cannot be recognized. So this is a first precaution that you can take and use in your everyday practice. Second is waiting on data to become historical. So there's no threshold when the data is already historical and can be exchanged easily. And this depends on the characteristics of the market. But if you know that some data needs to be exchanged, then it is possible to wait for the data to be a little bit more historical. And of course, based on individual assessment, it's possible to kind of create the idea on when in this specific market the information becomes historical. And as a last point is setting up firewalls. So if you're a supplier who also has your own retail outlet and you're worried about this information exchange between your own retail outlet and the distributors who have retail outlets. So first, you can do technical solutions for data availability within dedicated teams. So you have dedicated teams for your wholesale and for your retail. And you can do technical solutions there. So for example, retail data would be only accessible to persons active in this department. So also you can review the setup of your day-to-day work. If you have for example, information meetings regularly or emailing lists, you can review these and see if none of the retail outlet related information kind of flows to your whole sale department that can be kind of moved towards the distributors. So just review of this day-to-day setup. And of course, it's always recommended to have your internal guidelines and rule books on information sharing and between yourselves and the distributors, but also between different departments. And with regard to passing on data between the employees active in retail outlet and employees active in wholesale, then just to keep in mind that retail personnel should not ask for sensitive information about the retail market competitors from the wholesale personnel, and vice versa. The wholesale personnel should not pass on sensitive information received from their distributors, the resellers, to their retail personnel. So perhaps these setting up firewalls is also a good idea if you're a supplier active also in the retail level. But this is all from me, and of course I am happy to answer any questions you might have in the end of our webinar.